Good afternoon, everyone. I'm Michael Strawn from Oasis Senior Advisors, and today I have the pleasure of interviewing Chad and Scott Hales of the law offices of Robert E. Hales. Gentlemen, good afternoon.
Good afternoon.
Hi.
Good afternoon. How are you guys today?
Doing well, thank
Great.
you.
Excellent. All right, so before we get started, I was wondering if you could tell the audience a little bit about your background and your law practice.
Sure, yeah, you want to take a crack at it?
Yep. So Robert Hales has been practicing estate planning here in Southern California for about 35 years. And I worked for him here at the office for a number of years before I was an attorney as a paralegal, and went to law school here in Southern California. And when I became licensed to practice, I joined him here. And that was about 5 years ago, and I've been doing estate planning here with him for that period of time. And after I'd been here for a couple years,
I joined, yeah. So I practiced law after graduating from law school and clerking for a judge. I practiced law in the San Francisco area for a couple of years, actually about 13 or 14 years. And then I came down here in 2014 and joined up with Scott and my dad. And we do primarily, almost exclusively estate planning, probates, trusts, wills, and we handle trust disputes when they arise. We hope that they don't, but we handle them when they do. And anything really associated with estate planning and establishment of trusts and wills, we can pretty much handle any of that.
Well, excellent, gentlemen. Thank you for that information on your background and the background on the firm. Now I was wondering, could you talk a little bit about, a lot of people heard the term will and trust. Can you explain what is the difference between a will and a trust?
Absolutely.
so the will and the trust are similar in that they're both testamentary documents. They both say, this is what I want to happen to my estate after I've passed away. These are the people or the groups that I want to benefit from it. The biggest issue with the will is that in California, the will's directions are followed through a court-mandated process called probate if your estate is of a certain size. So for example, in California, if I have real property valued greater than $50,000 and I want that real property to pass to my children after I've passed away, before the home can pass to my children, it has to go through this probate process. And probate isn't the greatest process in the world to go through.
No, it's not the funnest. It's a court process that's overseen by a judge. Attorneys are generally speaking involved. It's time consuming, it's expensive, and it's public. So the trust has advantages over the will because it can be a private process after you pass away. Instead of having to go through probate, everything can be handled privately if the trust is created and you put assets into the trust. So the primary benefits of a trust are it avoids a probate process, which, number one, saves you money, because probate is generally going to be more expensive than establishing the trust and administering that trust after you've passed away. Number two, it's private. So whereas everything in a probate is a public record, a trust stays private. So most people don't want all of their financial information, even after they've passed away, to be available for the public to peruse it. Number three, it saves a lot of time. After the death, a trust can generally be administered a lot faster than the probate process takes, especially in Orange County.
All right, well, thank you, gentlemen, for explaining the difference between wills and trusts. Now, I know in trusts, it's important to keep it updated on a regular basis. So could you talk to why it's important to update and review your trust on a somewhat of a frequency because of changes in life? Could you talk about that a little bit?
Yeah.
Well, the easy answer is change. Life changes, your personal situation might change, your family situation might change, and the laws surrounding all of those things are changing on a federal, state, and local level. And if your plan isn't keeping up with those changes, then you're going to face unexpected consequences. And sometimes those unexpected consequences can be pretty serious.
Yeah. We get this question quite often, how often should I update my trust? And generally speaking, I would say every 5 years you ought to be taking a good hard look at your estate plan, the trust you've created, make sure it's still appropriate for your circumstances, make sure your circumstances haven't changed such that your wishes have changed. And often, things happen in life, and what we want changes, not necessarily about where our property goes, but who do we want to make healthcare decisions for us if we become incapacitated. That's something that may be different today than it was 5 years ago. There are often clients that will update their trust every year, or at least review it every year to reflect the latest changes in law, and that's certainly appropriate too. But at least every 5 years, I'd say give it a good hard look and make sure that it's reflecting what you want it to.
Yeah, a good recent example of that is changes in tax laws that have taken place over the last 5 years, and they've been pretty dramatic. Estate tax laws, for example, the amount that an individual can pass without incurring estate tax has shifted from $600,000 in the 90s to, as of just last year, over $11 million per individual can pass estate tax free. And that's a huge benefit to all of us in our ability to pass our estates on to our heirs. But if we have an estate plan that was drafted to maximize estate tax benefits 20 years ago, then it may have limitations in it. It may have provisions built into it that are not only no longer necessary and no longer helpful, but can end up being expensive and burdensome now.
Yeah.
And if we're not updating that plan, then we end up with troubles that we really don't need to end up with.
Yeah, that's a really good example. That has to do a lot with the AB trust, which some of the listeners may have heard before, but an AB trust can be a pretty complex trust. A lot of AB trusts were created in the 90s and early 2000s for estate tax reasons, and those may not be appropriate structures for that trust anymore, and it can save you a lot of heartache after the first death, a lot of expenses and angst if you get that updated now, or at least review it and see if it's still appropriate for your circumstance now. So that's a really good example.
Well, excellent, gentlemen. Thank you for explaining that. Now, could you talk to what are some of the biggest problems that clients run into after the passing of a loved one in relation to the trust?
Oh yeah, that's a good question.
Yeah. Well, I think one of the biggest potential issues with the trust after a trustor passes away has to do with one of the biggest benefits of the trust, which is the fact that the trust is managed privately. The person in charge of directing the trust after the creator of the trust has passed away is usually a close trusted friend or a family member. And that person's been picked because they were trusted by the person that put the trust together. But this is the kind of process that most people only go through once in their lives, since they've never been through it before, they haven't experienced it before, so they don't exactly know what they're in for. So this person who's managing the trust, the trustee, may not know exactly which obstacles or requirements or duties are in front of them. And it's a difficult time already because someone close to them has passed away, and now they're faced with a number of burdens and obstacles that they might not have been prepared for.
Yeah, and sometimes that will cause them to not do anything. And that's when we see a lot of problems. When a trust exists and somebody's passed away and nobody does anything about it, that generally creates a lot of problems. Sometimes it results in people using trust assets that maybe they shouldn't be using. Sometimes it results in trust assets not being managed appropriately, or actions not being taken that could have been taken to save taxes. There's a variety of different things that need to be done. So probably one of the best things we could say is that if you do have a trust, or if someone you know has a trust, and then the settlor or the person who created that trust has passed away, it's a good idea to talk to a lawyer. A lawyer's advice isn't always going to be necessary, but at least a consult with a lawyer to say, what are my duties, what are my obligations, what are things I should be thinking about, is a great idea.
It's oftentimes a really efficient way not only to save headaches and burdens and financial obstacles down the road, but to preserve family relationships as well.
Okay, gentlemen, well, thank you so much for your time and all that wonderful information. So if a client would like to reach out to you for a consultation or to set up an appointment to come by, what's the best phone number to reach you at?
Main number here at the office is 714-771-7671.
Excellent. And if somebody would like to look at your website to find out more information about you and your firm, what is your website address?
www.halesfirm.com, HALES firm.com.
Excellent. Well, guys, thank you so much for your time.
Great, thanks.
Thanks, Michael.
Thank you. Bye, everybody.